that she did not feel that it was appropriate for the father to exercise any parenting time with the minor children because they were present when the attack happened, and they are also victims of abuse at father's hands. There has been a DCS case opened in the past when father abused one of the older children to the point where he appeared at school with bruises that were significant enough to cause the teachers to call DCS. Father admitted to my client that he did hit the child. However, he said he didn't mean to hit him as hard as he did. Nevertheless, there is a long and demonstrated history of abuse on father's part against both my client and the minor children. Stevenson for Ms. Galligan. As you know, there have been several motions filed that are relatively identical in nature. However, I think realistically what this case, or at least these motions, are going to hinge on is the no contact order that is currently in place. The father is currently facing charges for simple possession of paraphernalia, and domestic violence, wherein the mother is the victim, and the father was forcibly removed from the marital home after committing an alleged assault on the mother when the children were all present. During this alleged assault, the police were also able to discover several items of drug paraphernalia and marijuana and other illicit substances. Father admitted to police that they were his and that they all belonged to him and that he is a drug user. These charges are currently pending in the General Sessions Court here in Humphreys County, and there is a no contact order as a result of the domestic violence charges that forbids father from coming in or around the mother's marital residence. In the actual reports filed by the police officers in regards to that case, mother's address is listed as the marital address. She does not have any other addresses at which she can reside. And father is explicitly ordered not to come around that residence. Now, since he was removed from the home, father has paid absolutely nothing in support whatsoever for his children. He has not paid any of the bills for the home. He has not provided anything at all to mother to support the children. She has raised them entirely on her own since he was removed from the home. Now,
when was he removed from the home?
It's been more than a month, Your Honor. It's been almost 2. So, as a result,
29th of April.
Yes, Your Honor. So, as a result of this, when father first appeared in the criminal case about a couple of weeks ago, I would say, he attempted to have his bond restriction that is currently in place, preventing him from contacting the mother, removed on the basis of the fact that he wanted to speak to his children. After this was presented in front of Judge Lockhart Mash, Judge Lockhart, my client, appeared without counsel. She was only a victim in that case.
This was in General Sessions?
It was not Judge Lockhart Mash.
Not Judge Lockhart Mash, I apologize.
Judge Lockhart Mash is the circuit judge. That would have been
Judge Maples.
It was Judge Maples, Your Honor. My apologies. It was just a slip up. But either way, Judge Maples aggressively questioned my client about whether or not the children could talk to their father, and my client testified that she did not feel that it was appropriate for the father to exercise any parenting time with the minor children because they were present when the attack happened, and they are also victims of abuse at father's hands. There has been a DCS case opened in the past when father abused one of the older children to the point where he appeared at school with bruises that were significant enough to cause the teachers to call DCS. Father admitted to my client that he did hit the child. However, he said he didn't mean to hit him as hard as he did. Nevertheless, there is a long and demonstrated history of abuse on father's part against both my client and the minor children. For those reasons, we do not feel that it is in any way appropriate for him to exercise parenting time while these charges are pending against him, and that if he is ever to exercise parenting time, he should be subjected to drug testing and he should be subjected to supervision, as he is clearly a very, very violent individual who is prone to take out his anger and rage on my client and the children. It's also important for this court to know that 2 of these children are not his biological children. They are my client's biological children from a previous relationship. Only 2 of the minor children that exist in this household are his biological children. The youngest 2, who are only 1 and 2, They cannot be without their mother for extended periods of time at this age, and he has never exercised any parenting time alone with these children. Mother has always exercised the vast majority of parenting time and is a victim of father's abuse, just like the other children. Mother has also submitted a notarized income and expense statement for this court to review, pursuant to the local rules of Humphreys County Chancery Court. That states exactly what her costs are, what she makes, and what she needs. As per our income and expense statement, she has a demonstrated need of at least $3,500 a month. While we know that that may not be something possible for father to reach, as it is quite a large number, we do know that he is gainfully employed and more than able to provide the support that she needs to raise the children. Quite frankly, it was shocking to us to see a motion for exclusive possession on the home and for support, knowing the fact that father has been explicitly banned from going to this house and has paid nothing whatsoever towards the minor children's care since he has left the home. Additionally, we would assume that somebody who has abused children to this nature and is now facing charges in a court of law regarding these abuse allegations would consider the fact that this no contact order is in place for a reason. Safety and assurance that these children will be able to live happy lives unadulterated by the abuse of the defendant. We would ask that Your Honor put in an order that prevents father from contacting the minor children until the adjudication of the abuse allegations. And we would ask that if he is granted any parenting time at any time in this case, that he be subjected to regular drug testing and to supervision, at least at the beginning, so that we can ensure that the children will be safe and well. Thank you, Your Honor.
Robert?
Your Honor, I don't know what case she's talking about. There are spatterings of truth in what counsel said, but far from the reality of what's going on. These parties have been married. They have 2 children. My client has not requested anything except from the 2 children. Yes, this woman has 2 other children that she's had allegations of abuse against. But again, there's no allegation of abuse of my client against these children whatsoever. I was present before Judge Maples when counsel was not, so I take significant issue with her not even being present in the courtroom stating what went on in court, because it was far from the truth about what went on. Judge Maple, I filed a motion to be relieved to modify the bonding restrictions so that he could have contact with the minor children. Mrs. Gallion appeared and said, nope, I'm not willing to talk about it. Why would I give him visitation? And I'm not going to do it. And so, again, it was Judge Maples did question and said, were the children, I've read this affidavit, the children were not involved in the abuse. And she entered an order that I can present to the court during the hearing that the Chancery Court has full right to modify the bond conditions to allow to allow whatever contact this court does as far as the children are concerned, that the bond conditions will be modified pursuant to whatever this court rules. But Ms. Gallion was using the criminal process. It was obvious to Judge Maples as well as to myself that Mrs. Gallion was using the criminal court position to position herself in this court, as many alleged victims do. There was an allegation previously to Department of Children's Services that was unfounded. Counsels uniquely left that off, that it was unfounded. And again, it always is just amazing to me that someone will come before the court and talk about how someone has been abusive to these children for such a long period of time. She puts in her affidavit that they're locked in the rooms, they're doing this, they're doing that. Yet she never stood up and protected these children on time until she decides to have this child, to have him arrested. Not one time has she ever made the allegation of abuse in the past, other than the report to the Department of Children's Services. That came back as unfounded. So if a modicum of what counsel says is true, that she failed to protect these children, that her client failed to protect these children from these heinous things that she's alleging my client supposedly did, she's worse than he is, because she had the opportunity to protect and didn't do it. But I say, None of it is true, Your Honor. My client has works. He works at the Gulf Club of Tennessee in their hospitality section. She's a waitress. He has provided care for these children. The very idea of saying he's never been alone with the children and to have a sexist comment to state that children can't be removed from their mothers because they're 1 and 2 years of age. I mean, what century are we living in? Again, tender years doctrine was abolished in the state of Tennessee, I believe, in 1969, a few years after my birth. So that's never been the law in the state of Tennessee during my tenure as an attorney. He has provided care for the children. His father was the babysitter. He was present during this so-called abuse allegation that she took place, which she came up, jerked the keys out of his hand when he was trying to go to work, saying, "You're not taking the car." There is no allegation. My client had, as I would say, gas station drugs, perfectly legal in the home. She lied, told the police where they were in the home. They said, "Are these yours?" He said, "Yeah, they're mine," but there's not been any testing. For an officer of this court to come in and make an allegation that those were illegal drugs without even knowing it, I think it's inappropriate.
Objection, Your Honor. We're not here to relitigate the criminal case. These are charges that are pending before the court. It's not me or Ms. Roberts or any of our clients' job to make charges or decide what charges should be. The police decided to charge him with simple possession of an illicit substance, not us.
Based on the allegation, the sworn statement of her client stating that it was marijuana.
When I have to make a decision regarding the custody of minor children, the two parties basically are opening their lives entirely for me to examine any evidence that relates to their fitness and their credibility. So therefore, anything having to do with these criminal charges would be relevant. It goes to the issue of whether or not they're a fit parent to either, have custody. So
Certainly, Your
your
Honor.
objection is overruled.
Certainly, Your Honor. But the only thing that I
Your objection is overruled.
This is a different objection, Your Honor. My secondary objection would be that as counsel, it's certainly not relevant to get up in front of a court of law and say or state that she didn't protect her kids when she's a victim, or that her attorney is lying or saying things to this court that are incorrect. I'm an officer of the court just the same as Ms. Roberts is, and I did not say those things about Ms. Roberts. So I would ask that we try to stay on the facts rather than launching personal attacks. Thank you.
And your objection as to the basis for Ms. Roberts characterizing your client as being untruthful or failing to protect is overruled, because this is, again, as I've said, a case where the two of you are going to essentially try to gut each other in the courtroom so that each of you will try to show the worst aspects of the other so that you can obtain an advantage. This court's job is to look to the best interest of the minor children. And as far as any sort of personal attacks of the attorneys, I prefer that it not take place in this courtroom. But I also understand that both of you are very capable lawyers, and I will allow you to try your case. But let's keep it to the facts of the case rather than what.
And Your Honor,
thank you, Your Honor. I appreciate it.
And Your Honor, Mrs. Stevenson is going on what her client told her just as much as I'm going on what my client told me. That's from that perspective. But when it goes into a court of law that I was there and Ms. Stevenson was not, is what I take issue with, on saying what was said when she was not present by the court. And that was the issue that I had on her stating. I wanted the court to make clear that she was not present in the court and witness, and that Judge Maples specifically ruled that the residential.
I'm going to decide this case so that everybody understands. Right. I'm going to decide this case based on the evidence before me today and what I find to be the best interest of the minor children. It is not going to be decided based on what another judge has or has not said or has not heard. It will be heard and decided by me from the witness stand today. And while statements of lawyers and their opening statements are allowed to try to give me an idea of what their case is going to be about, the statements of lawyers are not evidence. Neither Ms. Stevenson nor Ms. Roberts' statements are going to be, I'm speaking to your clients now, neither Ms. Stevenson or Ms. Roberts' statements to me about what has or has not transpired is going to be considered by me as evidence. It is their indication of what they think the case is about and what they want me to do. I'm going to decide this case based on, you put it in my hands, I'm going to decide it based on what I think is the best for your children. And neither one of you may like what I do at the end of this day. So we will go forward from that. Ms. Roberts, anything further?
That's it, Your Honor. And again, what we're requesting, again, if she's going to get possession of the home, she needs to pay for it. He will be entitled if he gets possession of the home. He will get it. There has been no ruling of the General Sessions Court on who has possession of the home. So I want to make that clear. The court has not ruled who has possession of the home. It's wherever she's living. The General Sessions Court has sole province of having no contact order with her. I do not disagree with that. But all of the other issues are not before the General Sessions Court. And any indication that they are is incorrect.
All right, Ms. Stevenson, is the rule requested? The rule has been requested, then we'll need to have anyone who's going to be a witness other than the parties go outside of the courtroom and remain outside of the courtroom until you are called to testify. You're not to discuss the testimony of any other witness until you yourself have testified. Counsel are under continuing duty to ensure that that rule is complied with.
And Your Honor, we just have one more concern that we'd like to address. Pursuant to the local rules of Houston or of Humphreys County Chancery Court, we were supposed to each have filed a notarized income and expense statement as well as a copy of our proposed parenting plan, and we have not received either of those things from the opposing party. It's difficult for us to move forward and decide exactly what support amount is appropriate if we don't have any sort of statement that is detailing what he makes,
Ms. Stevenson, that is a rule that is in the local rules, but it is a rule that is more observed in its breach than in its compliance. So it's not unusual to have that situation happen. I will take a recess for you to discuss with Ms. Roberts if that information is available, and that will give you an opportunity to prepare. We'll take a 15-minute recess.
Great, thank you, Your Honor.
All rise.
I'll get it to you. We have got the, I called your office repeated times asking for I had prepared. Yeah. We got, I came down here to get, I was getting ready to file a complaint for divorce.
Oh,
okay,
sorry.
I was getting a complaint for divorce.
Here's why.
And then y'all, I found out that you were representing her. Okay, I found that out in a roundabout way, just to let you know. When I was in court, I understand, and I'm saying this in front of both of them, if it's okay with you. She had gone up here to seek a order of protection and talked with Stephanie in there. I think Stephanie told her inappropriate information and told her that she couldn't give one because there was a bond condition downstairs. I think she went back downstairs and talked to the ladies downstairs, and they said, no, that's a civil matter. You can get it. So she got some. Your client got some very inappropriate information.
Not like you didn't do
You didn't know she didn't do anything wrong.
You the wrong info.
They were giving her the wrong info. At that point in time, when I found out about it, I did some snooping, and that's when I found out that she had, at some point in time, and again, this may be incorrect, when we appeared on that, she may have told me what your name was and if she had retained. Okay. Then I reached out, and your sister or whoever said, yes, I've got the complaint. I've sent it to Waverly.
Yes.
So I took my complaint and waited. Then I called and said, hey, have you got it? We haven't got a stamp file. When I say call, please, maybe a text, maybe an email.
I've got it.
But said, no, we haven't got it back. So I called down here and said, the minute you get it in the mail, can you send it to me? So they sent it to me before y'all sent it to me.
Yes. Because
so I was trying to see what was alleged so I could change mine into an answer and counter complaint.
Got it.
Okay. And I didn't get it. So that's why the pleadings are such.
So here was the
And then, so that's, it was just a snail mail.
we're not using that. So we originally tried filing it not by mail.
This is the parent.
But with all of this.
Right. But that's where it was. I had done a complaint for divorce. and had it ready, and then I had to change it into an answer and a counter complaint. So that slowed down the process on getting it. So that's where we were both getting back and forth, because that's where we had not done.
So we were sitting there with this. Yeah, like we're so lucky this come back. So I appreciate you.
So that's why we got it.
Yeah.
So we got the answer from the counter complaint that has not been, we went on and our motions actually got here before your answer counter complaint. I don't know. So that's where, if he said that mine would file first, well, technically mine would file first, but there was no file to follow me. I mean, because I had thought since you had mailed yours, I mailed mine thinking that yours would go and then mine would go, but mine got filed before yours did, but there was no file. I don't know how they created file.
I can't look them up. It's like sometimes my stuff will get there the next day, sometimes it won't get there till like 3 months later, and I don't have any way to learn. It's crazy. But,
And he had sent me his paycheck. He sent Friday after we had left. Right, I know, just hang on. So I had provided him with an income expense statement, and he did not give it back to me. So where is it? Where is it? I gave you a form for that. So I'm going to give you this as a paycheck. This is his. He gets paid bi-weekly. $3,070.38. Bi-weekly. I'm going to run and go make you a copy of this. The 22nd. 6/22.
all right.
Now, as I understand it, they rent the home, right? You don't own that home?
They own
They own it. Yeah, they own it. It's in joint names.
Yes.
Well, I think probably. Yeah, okay, let me go out and make copies of this for her, and let's talk a minute to see what we can do. Okay, so you just, I bet that's and that's what that's. But I know that's. Just stay here. You know what I'm going to ask you to do. Let me hang on. Would you rather stay in here and him go out, or would you go out and he stay in here? Okay. I didn't know. You stay in here. If you have to leave, I'm going to tell one of the officers. Okay, because I don't want any violations of the no contact. Okay, so you just stay here. Okay. Okay, he's not sick. We got the day for his sick, and it was said on I'm sorry, one of those I was doing some things one time to get your set, because it was just on what you said. I heard that.
So that's the day that.
Final hearing, that's it.
Really?
That's it. Yes, we need to get together between now and then. Sit down. So all office schedule. Sometime late, we probably said it sometime.
We're working on getting all that.
Well, I know we're gonna get all that stuff together. Okay. All right, you said it's 2018 is really. Okay, we'll get it. Okay. Thank you. Oh, we haven't set for hearing. Just give me the for hearing. We set for hearing on. Yeah, let me give you these hearing dates, Austin.
Yeah, you remember me?
Okay. If you would write down, we have James versus James on October 1st at 10:30. We have a Thornberry, and I'll get you the style of it, but is a grandparent visitation case. And I'm with Hillary and Reese are arguing over custody, and we're doing a grandparent visitation on October 5th, Waverly. That need to be resolved. So what we're going to do, Your Honor, is that today, Mr. Gallion is going to be able to see the kids at the home beginning at 1 o'clock for 2 hours. His father's going to accompany him. He's going to visit in the home. The babysitter's going to be there. Miss Gallion is not going, right? For you.
She'll be there, yes.
So the bond conditions will be modified that he can exercise visitation at the home, and that will not be a violation of the bond conditions. My client is going to voluntarily sign up and take an anger management class. He's going to get that signed up today. I'm going to provide that proof to Ms. Stevenson. She's meeting with her client, and we're going to work towards getting a more expansive residential schedule. We just need to coordinate my client's off, his days off, when she works, and sometimes she has to work late. So we're going to try to coordinate that. And so we're going to try to get that done, but in the event that we can't do that, we're passing this case to July 10th so that we can try to get a global settlement. As far as the home is concerned, Mrs. Gallion is going to make a concerted effort to see whether she can purchase the home and buy Mr. Gallion out. She's going to see if she can do that in the next 7 days. Mr. Collier, presently, I'm going to contact him to give an appraisal of the home. Because again, neither one of them want to sign a year's lease if the other one's going to buy, because my client would like to buy the home out if she's not, but she's going to get the first option. If she can buy him out, that's great. And then he'll need to get a more permanent residence. But if she can't, he's going to purchase the home, and then she can understand and have time to get that. So that's one of the reasons why we're trying to get this passed a little bit. The bond conditions are going to be modified. Their youngest child is having a medical procedure on the 8th. And so we're modifying the bond conditions that says that it's not a violation of the bond conditions for them both to be present at any medical appointment or procedure of either of the children. Of their children. And then we'll work towards getting that and then get the bond condition modified that while the criminal charges are going, he cannot, and just reiterate on the record so that he understands, he cannot have any communication with Mrs. Gallion directly. They're going to meet today at the home, and then Ms. Stevens and I will probably enter a supplemental order that they can meet to exchange the children, and that they can, and what I would suggest is through written communication, keep each other apprised of the physical condition, doctor's appointments, things like that. I'm going to suggest a parenting app that they can communicate through so that it's a record. And then hopefully we can get the criminal charges resolved and we can have a more full hearing on that matter.
Yes, and Your Honor, I just want to mention the only reason we're not giving you the full schedule today is just because our clients have unique work schedules, and so we need to submit it to sit down and think about it. But otherwise, they
both work in the hospitality area, and so their schedules are not a Monday through Friday 8 to 5 type scenario. So we're trying to coordinate that, and we both need to get those schedules. He's been able to get another day off. And so I need to communicate that. So that's what we're trying to do.
Well, I'm happy to approve the agreement that's been reached between the two of you, and I'm glad that you were able to resolve that through your lawyers. Let me just say a couple of things to you right now. And Ms. Roberts has heard me say this before, but I'm going to say it again. Your children have two parents, not just one. And while we have a situation that has arisen where the father has created a situation allegedly where Mr. Gallion is not being allowed to see the children. Right now, those are just allegations. I understand you know what happened, and Mr. Gallion has his version of what happened. But the fact of the matter is that you have two children together, I think, and then you have some other children. But right now, you've got to focus on what's in the best interest of your children. If you have issues, and obviously there was some sort of problem, there usually is fire where there's smoke. If there is a situation that has arisen simply because you let your temper get away from you, you need to address that. If you want to be a part of your children's lives, you need to fix the problems that are keeping you away from your children. If that is your anger issues, then voluntarily signing up for anger management classes is the best way to do it. Find a way to address those issues. If the two of you were not going to be together, then you need to find a way to tolerate each other down the road once the criminal things, all of these criminal things are subsided. You need to find a way to tolerate each other and to be able to be nice to each other. One way to do that is at some point you two had feelings for each other that led you to get married and led you to have children together. Whatever those feelings were, if you could try to remember them and try to recapture some of that and let this anger and hostility that's existed. But, children need to grow up in a home without the threat of violence, without the threat of arguing and fussing and fighting. They need to have a stable environment. And if you can supply that for them because you get some help, then that's what we want. We want the children to have their father in their life. But by the same token, Mrs. Gallion and those children deserve to live in a situation where they're not walking on eggshells and worried about when dad's going to lose his temper and blow up again. They don't want to have to worry about whether or not there's going to be some sort of an abuse and so forth. So it can be done. I can tell you that there are many instances where people have gotten their lives straightened out and they've gotten things taken care of. But we're going to do it according to your lawyers. You both have good lawyers and they're advocates for you and they'll give you advice. But the idea is to try to move you towards a more normal type situation so that your children can grow up together with the two of you co-parent. Because if you don't, if this continues with that anger and hostility, you're going to basically ruin your children's lives. Think about it from now. If you were a child and you knew that mom and dad hated each other so badly that they couldn't even be together unsupervised, then they're going to grow up dreading every major event in their life, every birthday, every Christmas, every other holiday. When they get old enough to start graduating, they have graduations from kindergarten, from 5th grade, from 8th grade. They do a lot of graduations now. They're going to want you both there, but they're not going to want you both there if they're afraid that you're going to argue and fuss and fight. I see cases all the time where mom and dad can't even get along well enough to be at the same soccer field or the same baseball field. And you know who suffers in that situation? The children. And having your children suffer is not what this court wants to see happen. So, keeping on with that analogy, eventually your children are going to get married or graduate from college, maybe graduate from high school. They're going to want you both there, hopefully. They're not going to want you both there fussing and fighting, because if you have the attitude that you hate each other so badly you can't even tolerate each other, you're going to not do anything but ruin those events for your children. They're going to be stressed. They're going to be anxious. And so I'm just suggesting that she has every right to feel that if you've been abusive towards them, verbally abusive or whatever it's been, then she has every right to expect that you're going to have to change your ways before the children can have an unsupervised situation with you or can be, safe with you. She has every right to feel that way. You have every right to think, I'm going to be the father that my children deserve. And if you are going to be the father that your children deserve, then you need to make the changes necessary to prevent anything else from happening. All of this is saying I'm not assuming any facts because I haven't heard any of the evidence. I'm not assuming that any of these facts are true, but I'm trying to get you both to start thinking from a different perspective, to think about what's in the best interest of your children and down the road what's in their best interest versus what's necessarily going on right now. Anyway, I'm glad you were able to reach an agreement. I hope you'll take what I have to say and maybe understand that my only desire is to try to see that your children are well cared for and that they're protected. Because I can tell you from personal experience that growing up as a child, when you have a lot of that going on in your life, you remember those days. You may not remember much when you were the age of your children, but you can remember things that happened to you when you were that. My dad was pretty angry and abusive World War II veteran when he was younger, settled it up, got control of everything, quit drinking, and became an established member of society in our town where we grew up. And people would have never believed that he would have been like that. But you know what? I remember what it was like when he was angry, when he broke up furniture, when he did things that has all of the 5 children hiding from him because of that. So you want that kind of memory for your children? Didn't think you would. So that you need to fix it right now so that you don't have that. All right. Then who's drawing the order?
I'll draft the order and submit it to Ms. Davidson for her approval, and then we'll do she can do the next one.
All right. Then I will approve your agreement, and it comes in order to the court today, even though it's not a handwritten order yet, not a typewritten order yet. It is an order of the court.
Thank you.
Thank you, Your Honor. I appreciate it.
We stand adjourned until 9 o'clock tomorrow morning when I have a criminal docket.
All right. I'm sorry, that was my fault.
Okay. This is.
Okay, we're gonna just head out. I'm gonna head out and get you guys.
Okay, yeah, just, that's what I was gonna give here, so y'all can go, and then he'll be over at the house. Okay, sounds good. Okay, so we will get.
Will you be here next Monday? We have.
Okay. 1 o'clock, so you're coming up, you got a few minutes, that's why we get it.
If you're a few minutes behind, like, that's fine. Yeah.
Yeah, so I'm gonna keep them here till y'all go, and then
I'm
you'll that.
happy to my docket
Okay.
when I send it out, because I had a.
No, I'll be at the zoo that day.
Oh,
What a
the
fun
zoo,
time,
that'd
yeah.
be fun.
I love the zoo.
Yeah, I
I'm
do
such a kid for
too,
zoo.
yeah. We're going, I think, we always go to. Dark.
Oh, he's huge. Well, he is. I don't know if that camera has a microphone. But anyway, yeah,
Yeah.
I'm excited. I haven't been yet this year.
Yeah,
I usually go
it'll be
every year.
nice, yeah.
And now they got puppies. Everybody knows we like the zoos. Great. The internet's aware.
Have a good one.
Yeah, good to see you.
You
We'll
too.
see you soon. You need a little basket. Your hands are so full.
Thanks. Years release. If I mention Yeah. What we're trying to do is, like I said, you need negotiation type. But he says, look, I'm happy if she wants to. So the percent has zero. Yeah, then he has $10. But that one. That. Houses, right, market for sale. Then he's gonna have to come up with that's something so. Something else.
The last status conference.
Okay.
So the case is still up in the air. I haven't gotten any authority from my client as to what we should dismiss it.
We'll just pass your motion on the docket without prejudice, but right now it doesn't appear you can take any action until the bankruptcy court deals with it. So, all right. Thank you.
Thank you.
2026 CV 33 regarding the conservatorship of Jacob Frederick Couch by Charles Couch Jr. and Karen Couch.
Nana, we're ready if you'd like to take that up.
Let's go ahead and take it up. All right, everybody's going to testify. If you'll raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
You all could state your names.
Charles F. Couch Jr.
Karen L. Couch.
Okay. And you filed a petition to be appointed as conservators for your son, correct? Is this your son seeing you today?
Yes.
And does he live with you?
Yes, he does.
Okay. Does he live with you?
Yes, he has.
And is there any reason, medically speaking, he's not able to care for himself or make his own decisions?
Well, he has Down syndrome and he's on autism spectrum.
So you're asking for all the rights of the conservator to be transferred to you by this court?
Yes, we are.
You filed a proposed property management plan,
Yes.
and you were proposing to manage any assets belonging to Jacob or income according to that plan?
Yes.
Okay. And his adult siblings have been notified of this petition, correct?
Yes.
Okay. And you've also filed a medical examination report that was signed by his physician?
Yes.
Your Honor, Mr. Chapman has also submitted a guardian ad litem report.
Yeah, I just reviewed that. So anything you want to add to that report?
No, Your Honor. Other than Jacob has a great DVD collection.
I was looking for the medical report, but I do find it attached to the original petition. So obviously this is an appropriate disposition of this situation, and no one is better suited to serve as the co-conservators than the parents. So I'm happy that you're both willing to step up and take that responsibility. All right. You have an order, Ms.
Yes,
Foster?
Your Honor. I also have my affidavit as well, which was just filed this morning.
Let me just say this. Obviously, this is a permanent medical condition, and while the law may say that you should have to come back in and submit an affidavit or a letter from a doctor or a report annually to sustain this conservatorship, I see no reason that you should have to go through that process. So I'm going to waive the medical report. I'm going to strike through where it says on an annual basis as to the financial and medical status. I'm going to strike through the medical status. Okay. I will initial that, Ms. Foster. So. Well, I have signed your order.
Thank you, Your Honor.
Thank you, Judge.
Good luck to you.
2026 CV 42 regarding the conservatorship of Flora Pyburn by Waverly SNF Healthcare LLC.
We're also waiting for Ms. Coffenberry, who's the guardian ad litem for that case, so we'll need to pass it. She should be here shortly.
2021 CV 67 regarding Regina Johnson.
Mary's also going. She did message me and say she's on her way about to be.
2023 CV 155 regarding the conservatorship of Jerry Crone.
Ms. Andrea Sinclair. Have a motion to withdraw. Apparently, Ms. Sinclair is of the opinion that file a motion and not appear, but it's the way, she's in the waiting room. I'll take that back. Ms. Sinclair, if you can hear me, you have been admitted to the hearing and we're taking up your matter, so I'm going to ask you to unmute and to turn on your video.
Thank you, Your Honor. Can you see and hear me?
I can see and hear you.
Thank you so much.
I spoke ill of you a moment ago. Not really, but I thought maybe you had thought you just had to follow the motion and withdraw and not appear. So I apologize.
No, thank you for hearing me virtually today, Your Honor.
No problem. You have a motion to withdraw, but also you have an order granting the costs and fees in this case. And this is if I recall correctly, this is the conservatorship of Jared Crone.
Yes, Your Honor. Yes.
Is there any opposition to this motion regarding the costs and fees or the motion to withdraw? Anyone here in the courtroom? No one here to oppose it, so I will grant both of your requests.
Thank you very much, Your Honor. I believe I've submitted proposed orders for both of those, but please let me know if we need to file those.
Submitted proposed orders, and I will sign them today.
Thank you very much, Your Honor. May I be excused?
You may.
Thank you so much.
Go back. Since Ms. Coffenberry, we passed a couple of your matters. Let's go ahead and start back over on the docket since one of them was an adoption.
Sorry.
Sorry.
2026 CV 64 regarding the adoption of Anna Joy Winter.
Morning, Your Honor. I apologize I was late. I thought it was going to take me less time to get here than it actually did. So this is just a petition for adult adoption. Miss Anna Joy Winters wishes for her stepfather, Brian Gardner Rains, to adopt her. He has basically served as his father, as her father for most of her entire life. And so now we just want to acknowledge that relationship and make it official. Everyone has signed the petition.
Right, if everyone will raise your right hand who is going to testify in this case.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Coffenberry, you may put on your proof.
All right. If you could, sir, please state your name.
Brian Rains.
And are you the stepfather of Miss Anna Joy Winters?
Yes, ma'am.
And have you all discussed that you would like to adopt her, make her officially your daughter?
For a long time, man.
And you're married to her mother, who's with us here, Nicole Rains. Yeah. Okay. And you've signed the consent tonight, perhaps. And if you could, your name. Go ahead and say your name.
Anna Winters.
Okay. And this is your stepfather. Yeah. Do you like him to officially be your father? Yes. Okay. And you understand that by doing that, Michael Hinson will no longer have any relationship to you. And you would like the judge to go ahead and approve that today and change your name to Anna Joy Rains.
I don't know if it's just a happy coincidence or whatever, but this adoption is set the day after Father's Day, but perhaps it was fitting that it could have been set for today anyway. I would like to compliment you, Mr. Rains, because being a stepfather is one of the more difficult things to do, to balance trying to be a parent without overstepping your bounds in a situation. And it's a high compliment to you that you have formed such a bond with your stepdaughter that she wants you to be her father in every sense of the word. So do you understand that if I grant this adoption today, that you will be her father the same as if she was your biological child in every way, shape, form, and fashion? That she will be able to inherit from you and you from her if God forbid something happened? That she will have the responsibility, moral responsibility to take care of you when you get old and infirm. So, but and Ms. Winters, do you understand as well that this is going to create a bond between you and your stepfather? He will no longer be your stepfather. He will be your father. You understand that? And you wish to have that bond created. Well, you are, I'm not going to ask you how old you are, but you are legally an adult, correct? Over 18. You have the right to consent. So with your consent, I'm happy to grant the adoption.
Thank you.
You have an order, Mr. Carpenter.
I have this ready, just let her sign.
Twenty 42 regarding the conservatorship of Florence Hyburn by Waverly Healthcare LLC.
We have Ms. Carpenter. There she is. Let's see if she's been over. All right. Petition for appointment of a conservator over a personal property of someone in Waverly Healthcare. SNF Healthcare, is that correct?
Yes, Your Honor.
Do you have anybody that's going to testify about the situation? Or?
I do not, Your Honor. Just the reported petition submitted along with the petition.
Your Honor, I've submitted my report on it.
Yes.
The proposed conservator is here, Your Honor.
So we have a medical report that details that the respondent has dementia, cognitive communication deficit, anxiety, unsteadiness, muscle weakness, and malnutrition.
Yes, Your Honor. Her dementia is relatively severe. She knows who she is, but she often can't remember the names of her children or her former husband or exactly where she is.
I have your affidavit of fees, Ms. Carpenter, but I don't see a copy of the report. Unless I've overlooked it.
I have the copy of the report, Your Honor.
I think it would be good to file a copy because unless I'm missed it.
Send it over to the clerk.
Did you send it today?
I sent it to him.
We weren't here Friday.
I know.
Let me see.
Okay.
I have an extra
Is
copy.
that an extra copy?
It's double-sided, I'm sorry.
It's all right. So she had a monkey named Squeegee.
Yes, Your Honor. Really.
She remembers that.
She heard all about her animals, the children's animals.
Sometimes animals are more loyal than children, so. All right, I've reviewed this, but I'm going to have this report marked. And if the new one, if your original comes in, so be it. But I'm going to go ahead and mark this as
That's fine.
mark it as an exhibit. But I found that this is appropriate that there be a conservator appointed. May I see that file?
Sure, and Miss Piper doesn't have any real assets except for potentially Social Security, and so we have had her to waive this conservator. I believe that the nursing home is going to be the representative payee for anything that she receives on. The main thing is just get her to be qualified for tenure.
Do we have someone that's been, you were appointed as the attorney ad litem. Do we have someone in mind to appoint as a conservator?
Miss Mason, Chair, Ms. Mason.
And you're willing to serve as the conservator of this individual?
Yes, sir.
We will appoint you to do that. I don't see, since there are no assets, there's any bond required or property management, since she has no assets. And Social Security, I assume, is going to pay her stay at the healthcare facility. All right. First, you'll submit your order, please.
Yes, I have a short.
Phyllis, let me ask you to sign this order, please. I think you signed it.
I apologize about that.
Sorry. I always repeat what Judge Robert Birch used to tell me when I submitted an order that I hadn't signed. If you don't care enough about signing your order, then why would I? So.
That's a good point. I'll make sure to have it signed next time.
Oh, that's not your order.
Thank you very much.
2021 CV 67 regarding Regina Clark and Johnson.
We can talk for a minute.
I think we need to talk just a
All
minute.
right, we'll come back to it.
2026 CV 149 Andrea Daniel versus William Daniel.
You skipped over Shaver.
2026 CV 19 Summer Shaver versus Jason Shaver.
Robert?
I represent Ms. Shaver, Your Honor. We're here today on a motion default, which took place on May the 27th. Judge Turnbull set it for today to give the defendant 2 more weeks to answer, and he has not replied or answered.
Jason Cody Shaver in the courtroom. All right. All those who are going to testify, raise your right hand and let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you.
Well, that's just about my default. He's supposed to be here. He answered by the 22nd.
Your default judgment is granted, so you want to put on your proof regarding the divorce?
You're Miss Shaver, Summer Sarah Shaver, is that right? And Jason, your husband, has been a kind of an addictive person all over the marriage, is that right? Has he abused you and the 2 daughters? Oh, well, your son.
You'll step up a little closer to that mic. So there we go.
He's never physically hit me, but he is mentally abusive.
But he does have a problem with addiction.
Yes, sir.
Has he supported you any?
Yes, sir.
My name is Morgan Mayberry.
And how do you know?
She's my best friend.
Is she? Okay. Have you heard what she said?
Yes.
Is it all true?
Yes, and I would also like to point out that he actually has child abuse charges for one of the cases.
One of these children?
Yeah, and then also he has neglect charges for getting drunk with the kids.
He has a no contact or the kids and the show. Out of general service. That's your name?
James Dodson.
James, I believe
I'm the father.
the father.
Yes.
You know your daughter to be truthful.
Yes.
And you've heard what she said.
Yes.
And you've heard what she said.
Yes.
Are they true?
I agree with both of those.
Okay. She needs to stay away from this case.
Yes.
Ms. Sugar, if you'll step back in front of the microphone, I've got a couple of questions. You have filed a proposed permanent parenting plan that basically makes you the primary residential parent and does not provide for your husband, the father of the children, to have any contact with the children right now. It's my understanding that based on his abuse of one or more of the children, that there is some sort of a restraining order or a protective order out of another court.
Yes, sir. The DA had granted a 2-year no contact between me and the kids.
Right, and is there a pending criminal case against him right now?
Yes, ma'am.
Let's let her answer, sir.
Okay.
I believe so.
And that's for abuse of one of your children?
No, sir. He got drunk behind the steering wheel and passed out with my kids inside the house.
Right. So he was behind the steering wheel of the vehicle while the children were inside the house alone?
Yes, sir.
How old are the kids?
My daughter will be 9 next month, and my son will be 7 in August.
Right. And he is the biological father of the children.
So,
Do you and Mr. Shaver own any real property?
just my vehicle.
Just what?
Just my vehicle.
All right. Well, that's personal property, so you don't own any land, or in other words. So you have your vehicle, but is that in your name only?
I believe he was the co-signer on it.
Okay, but you're going to keep that vehicle, is that
Yes,
correct? Right.
She wants custody of the children, Your Honor, and the parenting plan sets out the child support. It's been filed with the court.
The parenting plan, your father decree provides for him to have supervised visitation. Is that what you're agreeable to?
Yes, sir. Yes, sir. I would like the supervised visitation only with me, so I cannot trust anybody else with my kids.
That's in there, Your Honor.
I know it's in the final decree. I'm looking at the parenting plan that was proposed, and I want to make sure the parenting plan is more important because sometimes they get separated from the final decree of divorce, and it is that parenting plan. And under subsection B, it says the mother shall have responsibility for the care of the child or children except for the following times when the other parent shall have responsibility. The father shall have supervised visitation with the party's minor children until the father, and further, the father will contact the mother 1 week prior to schedule his visitation. So even despite those issues you talked about, you're willing to supervise his visitation with the children?
Yes, sir. My kids are super young, and as long as I can be there to supervise, I don't mind.
Anything else, Mr. Bradley?
No, Your Honor.
Granted the default judgment, but she is awarded a divorce on the grounds of inappropriate marital conduct. I will adopt her proposed parenting plan, which has previously been filed with the court, and I'm going to sign that one that was filed with the court, unless you have another copy that you want me to sign.
I have one here.
It's always better to have a separate copy attached to the final decree. So.
Didn't hear that, Your Honor.
What does he do for a living, Miss Shaver? What does he do for a living?
Honestly.
Well, I always prefer honestly rather than something else, but you can.
I think she's been the breadwinner of the house.
So you have down here that he is required to pay child support, and he's not at this point.
We calculated
Based
according to
on
the guidelines, and
you imputed income to him based on the guidelines. Is that correct?
Yes, sir. I believe I gave them my taxes for 2 years ago.
Right. Where's the place for me to sign on this proposed county plan that will attach it and mark it, file as a part of this final decree? All right, thank you.
thank you. Yeah, she has that question, Your Honor, and she,
So previously, as stated in the divorce papers, I had said that I wanted to keep the last name Shaker. I believe there's too much attached to this last name, and I would like to get rid of it.
What's your name? You can change it to whatever you want. So,
her maiden name returned, is that right?
your final decree does not provide that. Mr. Bradley, all you need to do is file an amended final decree that does change her name. Just add that specific provision, and that way it'll save you having to file a new action to change your name.
We don't have to have hearing or anything.
No, submit an amended final decree changing the name, and I'll take care of it.
Thank you, Judge.
Right.
Thank y'all.
Yes.
Twenty 149, Andrea Daniel versus William Daniel.
Your Honor, this is my motion for a wage assignment. Your Honor, we were here before the court back in February and took a default judgment against Mr. Daniel, modified the residential schedule and the child support. The court ordered that Mr. Daniel's new child support be effective in February. He's failed to pay anything. So I did not include in the default a request for a wage assignment, so I filed this motion just requesting that I issue a wage assignment so that we can ensure that his child support is paid.
Then your request for a wage assignment would be granted without opposition.
Thank you, Your Honor.
2026 CV60 regarding the conservatorship of Emmanuel Devaney, Richard Devaney.
Right, you've been admitted. I'm going to ask you to turn on your video and unmute if you can hear me.
Sir, if you look at the design office, please.
So
Can you hear me, Your Honor?
I'm going to ask you the same thing I always ask your mentor, Mr. Flanagan. Are you driving at the moment?
No, sir. No, sir. I'm in park. I can improve that there. I'm in park.
We have established that Mr. Spratt is in park, so we may proceed.
Your Honor, I'm here on behalf of Mr. Odle. This is his, Mr. Devaney's petition for appointment of conservator.
You'll raise your right hand. Let's place you on the road.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
Can you state your name for the record?
Richard Devaney.
And what is your relationship with the respondent, Mr. Devaney?
I'm his daddy.
Okay. And does he have a relationship with his mother?
No, man.
So his next closest relative would be his sister, Miss Ruthie Brown?
Yes, ma'am.
And was she made aware of this proceeding?
Yes, ma'am.
Okay. And did she express any objection to this proceeding?
No.
Your son, Mr. Devaney, he's been diagnosed with schizophrenia. Is that correct?
As far as I know, yes, ma'am.
Okay. And you are seeking to be appointed as conservator at this time on a temporary basis in order to make all decisions for Mr. Devaney. Is that correct?
Yes, ma'am.
And does Mr. Devaney have any kind of property?
My son?
Yes.
No, ma'am. Well, he's got a vehicle.
He has a vehicle. Okay. Does he have any kind of income of any sort?
No, ma'am.
Okay. Are you asking to make all decisions on Mr. Devaney's behalf?
Yeah, mental ones, you know, for him to get help, however I want to say it.
Is he in the hospital right now?
Yes.
Middle Tennessee?
Yes.
I don't show, so I don't show a copy of any medical reports. Are we going to be filing some?
I believe it was faxed on Thursday, but we can absolutely file that.
Well, let's just make sure. We'll follow up on it, but I need to make sure there is a report filed. So.
He has been admitted there 4 or 5 times.
I saw that in the pleading that you filed.
Sorry?
I saw that in the pleading that you filed that he had been admitted to Middle Tennessee 4 or 5 times.
Yes.
So we do have a physician's report from an examination that was completed on June 18th. We can file that today if it is not filed. And I believe that Mr. Spratt went and served and met with Mr. Devaney this past weekend.
All right, Mr. Spratt, you were appointed to be the guardian ad litem, so can you enlighten me? I don't have a written report, but are you able to give me insight as to what your interaction with Mr. Devaney was?
Yes, Your Honor. I met with Mr. Devaney yesterday at Middle Tennessee Mental Health Institute, and I've reviewed the report. I also believe Mr. Odell's office filed that Thursday. I haven't done my own report, but I met with him for about an hour yesterday. He's diagnosed. The diagnosis is fairly evident. He first said he wanted to consent to this, and he revoked that consent later. But there were some incoherent statements during that revocation. So I certainly advised him. I served him with this suit also, and I had given him the notice of hearing as well. Advised him of his rights. He did not request an attorney ad litem. I explained what that was, but as of now, he opposes the suit. I informed him that my position would be that the conservatorship be granted, and I informed him of what my role was as the guardian ad litem. I explained the notice of rights to him specifically, and he had some paranoid concerns. So it's my position it should be granted. I don't know if the court wants to set a review date or something of that nature. But
so, do you have any questions for Mr. Spratt?
Nothing further. Mr. Spratt, did he disclose any kind of property that he has possession of?
Well, as far as that went, and I'm glad you asked that. He told me that he owned the house on Sunset Drive, and that he had $800,000 in the bank. At the same time, he knew that I was Jelly Roll's cousin. So
I didn't know that.
I didn't either, Judge. But it was.
I can see the resemblance. Other than the tattoos, I can see the resemblance. So.
Well, it was a very, very fluid transition from consent to non-consent.
I have experience in dealing with clients who were suffering from paranoid delusion, paranoid schizophrenia. And I think it is clear that with the medical report that obviously has been filed, I haven't seen it, but subject to that, to my review of that, it is clear to me that he is in need of a conservator, and his father is the appropriate person to serve in that. I do think it's probably a good idea, as Mr. Spratt had suggested, that we go ahead and set a review date. Do you have a date, say maybe 60 days down the road?
That sounds good. And we had prepared an order to appoint him on a temporary basis with a review hearing.
The temporary, that's what I was going to suggest. Let's do it on a temporary basis, subject to. Sometimes people who suffer from schizophrenia, if they get appropriate medication, stay on it, they're functional. But obviously, if he's not, trying to help himself, then he's going to need somebody to try to help him with that.
August 27th or 28th.
August 27th or 28th. Mr. Spratt, do you have your calendar anywhere?
I don't. But I believe that'll be either one of those will be fine, Your Honor. I can do a
August
report in case I have to have somebody stand in that day. I'll do a written report.
I would suggest that so that if somebody does have to stand in for you in case you're in concert or whatever. So.
I'm just a stage hand.
Well, I would think your cousin would give you a better job under those circumstances. So that explains a lot about why we never can get you in court.
That's right.
Mr. Spratt, you need to sign this order on your behalf.
Yes, absolutely. And for the record, Your Honor, I have the return summons, the original, and I'll bring that to Waverly today for the file.
All right.
I can email Madam Clerk a copy of it if we need to do that, but I will bring it to Waverly today.
If you're bringing it today, that'll be sufficient. All right. I will sign the order to tell your cousin Jelly Roll that we all said hello. So.
Thank you, Judge.
I will do it, Judge. And, hopefully somebody can save me, as he says. So. Thank you, Your Honor.
Thank you. And I sign the order.
Thank you.
Twenty 26 CV 62 Casey Show versus Mark Dozier. Mr. Dozier served. We don't have service back that he has actually been served with your petition. So there was an ex parte order of protection issued by Judge Lockhart Mash on June the 11th, and that one has not been, we don't have the return that he's actually been served and notified to be here. So what I'm going to suggest is this will remain in full force and effect, but it will be continued until we can get him served, and then you'll be given notice.
Okay. All right. Thank you so much.
Thank you. We'll get it later.
2025 CV2 Daniel Jones versus Jennifer Jones.
Yeah, that's here for a hearing and they just stepped out. Probably need to mark after discussion just briefly if we could.
All right.
2021 CV99 Christy Thornberry versus Tristan Thornberry.
That's Mr. Duke's motion for formal visitation. I understood it was set today, maybe to get a date to have that actually heard rather than have this heard, but she's out, so.
All right. We'll come back to it. Let's run through and see what else. So how long do you think your Jones case is going to take to try if we have to have the hearing? I assume you will.
The rest of the day. We have division of assets in custody. Adoption.
Just the case that I've heard before.
You've had one other hearing, maybe two other hearings in it.
Right.
So that's why I think we just don't wanted to have a brief conference to narrow down the issues on what we're going to do, consistent with the prior order that we have for your signature today.
All right. Then we also have Gabriella Gallion versus James Gallion.
Yes, Your Honor, those are my motions. I filed motions to adopt a temporary parenting plan. And this is Ms. Stevenson from the Nashville Bar. She's also filed reciprocal motions.
Okay.
Yes, Your Honor, and I apologize if they were in the style that this court is used to. I'm from the Davidson County Bar, and typically when we get these motions filed, we file counter motions as their own motion. I'm not sure if that's how the court likes them down here, but that's why we filed them separately.
We're all here asking for the same thing, just different relief.
It seems to be fairly apparent that you all are asking for the same thing. So, yes. All right. Well, you're behind the Jones versus Jones case, which I'm told is going to take all day to try. So you and Ms. Roberts may want to talk about your case. I'm going to take a recess and let you all try to discuss whatever. And if are you wanting to have a conference with Ms. Duke and and myself.
I think so. Yeah, Ms. Duke and I've got an order prepared that needs to be entered from the last hearing that we need to provide that. I don't know if she's passed that up to you. Okay, we've got to get that entered and then we'll be ready to, there was an issue about selling the house, so.
All right. Well, I'm going to take a recess to allow you and Ms. Duke. I'll be in chambers if you want to come.
And then there's still the Miss McLeod's case. Somebody went out and dropped off on the van. The van called her. She's out. Well, yeah, usually. Yeah. Okay, this is all. He's our court reporter.
Yeah, let me get your.
Yes, absolutely. Here, I got a card. Is that better?
Yeah, that'll work great. Do you want to share today? Well, I guess it
I think it depends. I'm not sure.
I don't think.
Okay.
Well, again, there's, if we could resolve the custody issue, I don't know how much summarized Hillary is. I'm going, yeah, unfortunately enough.
Yeah, at least I'm not from the town. Yeah, I'm sorry. I don't know if that's not
Okay, she gets those people dirty.
I moved further away.
I thought we were just getting a date today.
Well, he stood up to say that.
And that's what I said.
He
I didn't.
When you asked me, could I continue, and you were gonna continue to try to, could, and.
It's not. I just didn't have my client come.
Well, and my client's out of town. My client supervised.
Yeah. Let's all go and just get another date.
I'm not really involved, but I am from.
No, you are involved because they quit.
But they're.
But the other thing, I'll tell you.
They're out of town.
Yeah, they're in.
We got a hearing plan. Yes.
Okay. Well, let's just get a date.
Well, they're not operating. If you're willing to operate them.
All the visitations at the most discretion. There was some things he had to do.
No.
You were asking for grandparent visitation, so we gave him that and let him supervise.
No.
Unless he goes and gets like.
And it's not working.
No, you guys, my client is supervising your client's visitation. Your client's visitation. Yeah, my client, but we haven't proceeded on the grandparent supervision. Yeah. Yeah, because it's his visitation, but my client has to supervise.
Right.
And so she wants just to have alone time. He wants to have alone time, and my client's saying, look, I'm submitting myself to the jurisdiction of court. It's gonna be here. And so let's just get a date and then I can come back and get the rest of my stuff done.
I'll be back.
How you doing, JP?
I've got to go grab a quick thing.
I forgot last week. I'm like, well, we'll do it Monday.
All right. Yeah.
Yes, ma'am. Yes, ma'am. No, I'm sure. I miss that little Katie. Dr. G, we call I had a new kidney skin. Better than the old. Well, I gave you some for urination. I think it's that's what I need because we're making me get out too much at night. After the operation, I had 4 prescriptions. Okay. Little bitty pills. How do I get in touch with you? How do I get in touch with you? Well, I haven't been taking, the only thing I've been taking is that little strip. Well, I don't know. What's her name? I called the nurse and I need to go. I got out of, I was my primary care doctor. They moved the doctor video on the he don't do anything right anyway. Awesome. I lost all faith in him. Oh, yeah. He ain't never gonna get invited. Never. Don't wanna go. That was all on fault. Had nothing to do with it. No. It'd be good to me. Set up the appointment. What? I'd rather do that than I'd try to keep. I think so far away. Nurse Laurel, we need to first, which we're talking to. Okay. And I carry the cell phone on me all the time. I'll answer. Nice talking to you, Dave.
We had meetings with the counsel for the Jones versus Jones case, and we've set that for a final hearing. And then we've also set a hearing in the Thornberry versus Thornberry, so those two are off today's docket. That brings us to Gabriella Gallion. I'm sorry, we need to take up your case, is that correct? Yours and Ms. McLeod's.
If we can, Your Honor, Ms. McLeod and I had an opportunity to go over some of these things together with Ms. Lisa. And I think we've narrowed it down and we have an agreement about how this fees will be reimbursed.
Yes, Judge, and before we get started, I wanted to call the court's attention to the affidavit of Jim Foster. There's a typographical error in it, and that I put that he was appointed as conservator on paragraph 3, and that's a typo. He was never appointed conservator in this matter. Just wanted to clear that up for the court record.
Okay.
And Your Honor, I had filed a motion to approve some fees. And after discussion with my client and with Ms. Lynn, who's the guardian ad litem, we have come to the following agreements. As far as Miss Lisa, we've agreed that she can be reimbursed $1,333, which is for, let's see if I got this right, for medication assistance for the ward. $1,239, which is a mortgage payment for the ward's residence, which they covered for her when she fell behind. There's also a fee of $1,960 for the phone bill for the ward that my client has paid. There's attorney's fees in the amount of $2,500, which will pay to me. And then there is mileage expenses in the amount of $14,352.00, which accounts for 4 years of driving back and forth between Franklin and then Spring Hill and here in McHugh. And she has kept a record of all those and has submitted those to the guardian ad litem.
Pages and pages of that documentation, and I agree with that.
And Mr. Jim Foster is not here. He's out of the country today. He did sign this affidavit. He had incurred expenses of $25,651 in the form of renovations for the ward's home, which was later sold, and the money deposited in the conservatorship account. We've also reviewed those and provided receipts of those expenses. He was married to Miss Faye, who was co-conservator in this case, but she sadly passed away. This money came out of their joint account. And I think the guardian ad litem is okay with them being reimbursed that amount only. So we have proof that they did expend that amount.
And the house did sell for $185,000, so there should be some funds for that, and also from here for her. Those funds are spent.
And the last thing is that we have also talked about Miss Lynn's fees. We have agreed to add to an order if Your Honor approves these expenses that my client will also pay $1,906.50 in her fees as well.
All right, so everybody's in agreement with this?
Yes, sir.
It's all in agreement, then I will approve of that.
Under oath, Your Honor, is this about anything?
You what?
Do you want to put her under oath for any reason, or?
Yeah, let's go ahead and do that. If you want to raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, all truth, and nothing but the truth so help you God?
Could you state your full name, please?
Lisa Taylor Gray.
And are you a co-conservator for Miss Regina Johnson?
I am.
And who is she to you?
She's my aunt.
Your mom's sister?
Mm-hmm.
Okay. And Miss Faye passed away. That was your mother?
Correct.
When did she pass away?
July 3rd, 2024.
Okay. And you've heard everything myself and Miss Lynn have told the judge here today. Is that all true and correct to the best of your knowledge?
Yes, it is.
Okay. Right, Judge.
Submit your order.
Thank
Judge, I will
you.
do that.
Thank you.
Thank you.
Concludes my business.
Galleon.
Yeah.
All right, we're down to our last case, Gabriella Galleon versus James Galleon.
Yes, sir. Mr. Gallion. I'm sorry.
Good to see you.
I'm about
I know, right?
Thank you.
All right, we have motions by both parties essentially asking for identical situations where just that parenting time and child support been done in lighting. And then this, Robert, you had filed the initial motion to adopt a parenting plan for temporary in possession of the marital residence. You
Yes,
filed
Sean.
those on June the 8th. And then Ms. Stevenson, you filed yours on the 12th. So we'll proceed with first in time, first in right, or do you want to go by the parties, whoever the plaintiffs are?
I don't have preference, Your Honor.
Ms. Stevenson, you're the plaintiff, so we'll let you put on your proof first. So you wish to make an opening statement?
That is no problem with me. Good afternoon, Your Honor. Chelsea